Chapter 29, Injunction, Miscellaneous Torts, Analysis. Section 629. No injunction of a libel as such except by statute. A libel occupies much the same relative position as a crime in considering the remedy of injunction. Equity will not restrain by injunction the threatened publication of a libel, as such, however great the injury to property may appear to be. This is the universal rule in the United States, and was formerly the rule in England. The present rule in England rests on statute. Section 630. Same. Libel may be enjoined on other equitable grounds. But while the libel as such will not be restrained, just as a crime will not be prevented by equity, yet when there is other legitimate ground for equity to issue the injunction, the fact that the publication is also a libel will not prevent the injunction being issued, even if there is a constitutional provision forbidding injunction against libels, as an interference with the right of free speech. It is clear that the grounds must be more than the injury to property arising from the libelous character of the publication. Thus, the publication of a libelous circular will not be enjoined when the injury to the property arises from the falsity of the charges, but where it tends to intimidate customers or workmen and injure plaintiff through their loss. The fact that the circular is libelous will not prevent an injunction against the circular. Lord Keynes, in refusing an injunction against a libelous insurance circular, said, "It is clearly settled that a court of chancery has no jurisdiction to restrain the publication merely because it is a libel. There are publications which a court of chancery will restrain, and those publications as to which there is a foundation for the jurisdiction of the court to restrain them, will not be restrained the less because they happen also to be libelous." Section 631. Same. The rule in England. Lord Keynes, in the case last cited, was stating the rule as the Court of Chancery worked it out. Today in England, as a result of parliamentary acts, equity will restrain the publication of a libel as such, contrary to the rule recognized by Prudential Azure Company v. Not Chitty, J. in Collard v. Marshall, explains the change in the rule thus: the Court of Chancery before the Judicature Acts had power to intervene by injunction to protect property, but not to protect character. It had no power to try libel. Since the Judicature Act, the Chancery Division has on motion granted injunctions restraining the further publication of false statements calculated to injure a man's trade. The present rule was stated first in Dixon v. Holden, and is to be found approved constantly since. Equity merely exercising its discretion as to issuing the injunction. Section 632. The right of privacy. Within recent years an attempt has been made to obtain recognition for a so-called right of privacy. It has been maintained, for example, that an individual has a right not to have his portrait or representation published in any form, without his consent. As yet, this doctrine has not been generally recognized, although a few cases now sustain it, and it was repudiated by a bare majority only of the New York Court of Appeals. The cases must be carefully distinguished from those in which a property right is involved, as where a photographer in breach of trust publishes a likeness, or where a party publishes private letters. In the latter cases the right to an injunction is established. If there is such a thing as a right of privacy, an injunction is certainly a proper remedy for its protection. Section 633. Injunctions to enforce the obligations of common carriers and public service corporations. Common carriers and public service corporations in general owe duties to the public. Individuals are entitled to enforce these obligations, insofar as they are themselves concerned, and when the legal remedies are inadequate, equity will grant its relief. Common carriers, for example, are under an obligation to serve all persons without discrimination and for a reasonable compensation. Accordingly, shippers may enjoin the enforcement against them of unreasonable rates, in order to prevent a multiplicity of suits. A mandatory injunction is sometimes awarded to compel a carrier to transport freight or to furnish proper transportation facilities. Unjust and illegal discrimination may be a reason for equitable interferences. Relief may also be had against a violation of duty by general public service corporations, such as gas, water, and telephone companies, when the rights of the individual complainant will be affected thereby. Section 634. Injunctions against certain frauds on contractual rights. Ticket scalpers, dealers in trading stamps, Within recent years, courts of equity have exercised jurisdiction to restrain ticket brokers from dealing in non-transferable railroad tickets. The grounds generally given for relief are the prevention of a fraud on the complainant and the avoidance of a multiplicity of suits at law. Dealing in such tickets constitutes a tort, based either upon the interference with the contractual rights between the railroad and the holder of the ticket, or upon the fraud perpetrated by the wrongful use of tickets by persons not entitled thereto, upon the complainant's business. Each ticket transferred gives rise to a separate cause of action, and when the number is great, many suits at law are necessary. Such remedies are clearly inadequate, and accordingly an injunction is proper. It has been pointed out in some of the cases that the use of such tickets constitutes a fraudulent interference with the business of the railroad, and that great loss therefrom may be suffered. It is questionable whether a violation of law by the complainant in the matter of rates is a ground for refusal of relief. The maxim, "He who comes into equity must come with clean hands," ordinarily applies only to conduct with respect to the subject matter. The courts are divided as to whether such a violation is in respect to the subject matter of the injunction suit. Much the same questions have arisen in a group of cases relating to illegitimate dealing in trading stamps. These were tokens, issued by a company to certain merchants for distribution to their customers on certain terms, non-transferable by them, and redeemable in merchandise by the issuing company when presented in a sufficient number by such a customer. The purchase and sale of such stamps, on an extensive scale, by unauthorized parties, in such a manner as to work a fraudulent and unfair interference with the issuing company's contracts and serious damage to its business, has been enjoined. Section 635. Injunctions for the protection of electric currents. The interference with wires in a public street by the stringing of other wires in such manner as to cause electrical induction and the injuries resulting therefrom, has been considered by the courts in a series of recent cases. In the cases which have arisen, neither party has been entitled to an exclusive right, both have had authority to use the street. As a matter of law, it is held that where a person is making lawful use of his own property, or of a public franchise, in such a manner as to occasion injury to another, the question of his liability will depend upon the fact whether he has made use of the means which, in the progress of science and improvements, have been shown by experience to be the best. Hence it is held that a street railway company will not be enjoined from maintaining a trolley wire in the center of the street merely because the grounding of the wire causes a current in a telephone wire, by conduction. Where, however, wires are strung so close to others as to cause induction, which might be prevented by placing the wires at a greater distance, a right is infringed, and an injunction is a proper remedy. The ground of the jurisdiction has been said to be that defendant's conduct is an unwarranted usurpation amounting to a trespass on complainant's rights, which is recurrent, continuous and tending to a multiplicity of suits.